Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to talk to you about all things related to Illinois family law. So today's question is, can I get back child support for my 22-year-old child? Or, to state it another way, can I get back child support for my child who is now an adult? So, you can, yes, in certain circumstances. You cannot file a new petition for a child who is already emancipated. And emancipation, meaning going from minority to adulthood, occurs either when the child turns 18 or certainly no later than 19 and their high school graduation. So if you have an 18-year-old who has turned 18 during their senior year of high school, even if they're going to turn 19 before the conclusion of their senior year in high school, they would continue to be a minor until they were 19 and had graduated from high school. In any event, or actually, let me take a step back. They would continue to be a minor until they turned 19 or had graduated from high school. All right. But once a child has turned 19 and they have graduated from high school, they're definitely considered to be an adult. So you can't file a new petition for an adult. That would absolutely be against the public policies. But if you had an old child support order that had been filed any time prior to the emancipation of your child, perhaps it was an order that was entered years ago that had never really been enforced, that had been accruing an arrearage or accruing a past due balance because of lack of payment by the payor, then you could go and you can ask the court to enforce that order. The petition that you would need to file would be a petition for rule to show cause for indirect civil contempt. If you're in the court system, I always like to give lingo so that people can understand the words and the terms that we use regularly amongst ourselves when speaking to the judge or speaking to other counsels. And so what you would hear is petition for rule. So you could file a petition for rule, asking the court to hold them in indirect civil contempt. And the ramification of being held in contempt for failure to pay child support not only include fines and costs, it includes interest payments that have accrued over the number of years that they have not paid, but it can also be punishable by jail time or incarceration. So when you hear sometimes that people have gotten their licenses suspended or their passports have been, denied, or they have gone to jail, they've been taken into custody on body attachments, that is generally because a petition for rule to show cause was filed against them. So they're very, very serious pleadings. So if you had a past due child support, and regardless of if your child was 19, 22, or 40 years old, and that order for child support was entered prior to them becoming an adult, then you could file your petition for rule to show cause at any time. Certainly, if you are not 100% certain about the amount of money that was due to you, not just because of the principal balance, meaning the actual monthly amount they were supposed to pay, but if you're also uncertain about the interest calculations, then I would simultaneously file what we call a petition for accounting or an accounting adjustment review, otherwise known as an AAR. So again, I just want to keep you informed and make you feel empowered by knowing some of the acronyms you're going to hear the courts saying. You would file a petition for AAR asking the state to show the records. Show us exactly what payments they owed in 1998, 1999, 2000, 2019, and show exactly how much he paid towards the arrearage. And then at the final conclusion of the allocation of parental responsibilities, tally up how much he owes me as principal, show me how much he owes me as interest. So accounting adjustment reviews are incredibly powerful tools and quite necessary to make sure that you get everything, all of the money that is due to you. And that includes principal and interest. And then lastly, once you have filed the petition for rule to show cause, you have also gotten the accounting from the state, from Healthcare and Family Services and the Child Support Enforcement Division, who keeps records of all child support payments enrolled through their agency. Then you would want to get a judgment, meaning you would want to get a court order stating exactly and down to the penny down to the dollars and the cents, how much it is that he or she owes you as an arrearage. And with that judgment, you would be able to use it to attach any assets that they have. You could ask for a wage garnishment. These kinds of remedies are done through a separate division. So in the domestic relations division or the family law court, you get your judgment. You get your accounting and you get the tally of how much he owes. And then you would want to go to, for instance, small claims court or the civil division to ask for that judgment to be attached as a wage garnishment. Or if you wanted to just keep everything in-house in the family law division and the judge was so inclined, you could say, Judge, he doesn't have any assets. He doesn't own a car. He doesn't have a job or, a W-2 wage where his employer could just deduct money from his paycheck. So I want him to be beholden to you, Your Honor. I want him to come to court and to show Your Honor every single month that he is making payments towards a specific payment plan. So that is another option. But in any event, regardless of how old the child support order is, as long as it is still a valid child support order, and as long as it was entered prior to the emancipation of your child, you can still seek arrearages. The last thing I want to leave you with is you want to differentiate getting child support for a child and college contribution. So let's say, for instance, this 22-year-old were in college, and let's say that that's really what you were seeking contribution towards. Just know that that actually is governed by a completely different section of the statute than family law, because college contribution is literally specifically for the purpose of contributing to the financial expenses of college. It is discretionary, meaning Judge A might find that it was appropriate in your case for both parties to contribute financially to a college education, whereas Judge B might say, no, I don't think either of the parties can afford it, so therefore I'm not going to force either of you to pay for college for your children. So know that it is discretionary. It is not granted in every single case. It's, the amount of money that each parent has to contribute is really going to vary from case by case and definitely from judge to judge. And so if what you're asking for is contribution towards your child's college expenses, just know that those cases are complicated, but they are winnable and they are filed every single day, particularly in the Cook County Domestic Relations Division. And so if you have any questions about how to move forward, either to recoup some of the arrearages that are owed to you for your now adult child, or to get college contribution, then definitely reach out to a trusted family law attorney. I hope that this has been helpful.